South Bend, Indiana Mayor Pete Buttigieg is officially running for president in 2020. The Democratic mayor making the announcement yesterday in front of a large crowd in the city he governs. Buttigieg raised more than $7 million in the first quarter of 2019 and has placed third in recent weeks in multiple polls of Democratic voters in Iowa. Lisa Carter, NBC News Radio.
If you're 85 or younger, would you like peace of mind and comfort for your family? We're Final Expense Direct with an urgent message for you. The average funeral today costs over $8,000, but the most you'll get from government benefits is $255. How will your family pay the difference? We can help. Our senior plans start as low as just $1 a day and pay up to $30,000 for a funeral and other final expenses. Peace of mind is easy. There's no medical exam. You'll have lifetime coverage, and your plan can't be canceled as long as you pay your premiums. Call now for free information about our senior plans. Answer a few simple questions and receive approval right on the phone. Plus, call right now and we'll give you a discount prescription card for free. Call 800-327-1660. That's 800-327-1660. Again, 800-327-1660.
It's time to make the Tri-City Center in Redlands a regular part of your weekly shopping experience. Tri-City is home to a wide assortment of quality businesses, including the all-new Ocean Aquatics. Check out their variety of exotic tropical fish, along with fish food, accessories, and tanks of all shapes and sizes. The Tri-City Center is located just off of Alabama and the Tennessee exits in Redlands. Visit the Tri-City Center today and find out why it's called the Mall with a Heart.
Erin here from On the Brink Morning Show, where we talk about all that is engaging in the Inland Empire. News, politics, business, family, things to do, and so much more. Join us weekdays from 6 to 7 a.m. on KCAA 102.3 FM, 106.5 FM, and 1050 a.m. or on KCAAradio.com.
The Legacy. Southern California's KCAA, the #1 talk radio station in the Inland Empire.
And now, it's For the People with Judge Herb Dodell.
Well, good afternoon, ladies and gentlemen. In our efforts, and our continuing efforts to make the show interesting, today what we're going to do is we're going to play 2 real live cases that were actually recorded in my courtroom. The voice you'll hear on it is my voice and the litigants. One of them we played about a month ago, but for those who don't listen to the show on a regular basis, they don't have the benefit of having heard it before, so we're going to play it again today. The subject matters are basically damages. What kind of damages can you get if you're involved in a lawsuit? Whether it's in small claims court, where I currently sit, or it's in part of a civil litigation, damages are well defined by the law and historical definitions apply. So today, I'm going to talk about concepts known as rescission, reformation, restitution, and specific performance. Those are what's called equitable remedies. There are 2 kinds of remedies. One is a legal remedy and one is an equitable remedy. And then there's a third potential source of damages called punitive damages. So I'm going to talk about that too. The 2 CDs that we have, actually one of them is the second part of the first tape, because there were 2 appearances. Nobody showed up the second time, but I did say something and I put an order on the record. What I'm going to do is I want to explain why I did what I did. I have options most of the time. There are legal calls and there are discretionary calls. The discretionary calls are pretty much what we feel like doing at the time, as long as it's not an abuse of that discretion. Legal is easy. The law is the law is the law. There's nothing to do in the way of discretion. So much of what I did today and what you'll hear on these 2 CDs were discretionary calls.
These are actual cases.
These are actual cases. These are the real litigants. One deals with a Timeshare, that's the second tape. And you'll enjoy they are really real. And if I had known I was going to be using these for something, maybe I would have done a little bit differently. But this was the actual responses that I gave to the litigants from the time. In one of the tapes, there's another case that comes along. The parties were in court, and I took it out of order. It was only a very short 30 seconds or so. But these are real. And that kind of differentiates us from just about anybody else that I could think of. So here you go. Gary's going to tee up the
Ready?
first one.
All right, here we go.
All right, number 2, M&N Financing Corporation versus INA Auto Body LLC. A case ending in number 1054.
Morning, sir.
And you are the representative of M&N?
Correct. My name is Michael Prater.
I was just looking for that. Just looking for that. I got the authorization here. Okay. Last time there was somebody else appeared.
Correct, yes. Patricia.
Yeah, Patricia Lawrence.
Right.
Okay, it is now 9:47. No appearance by the defendant. I read this file. This is for a storage fee?
No, it's he wants storage fees, the defendant. We are a financing company.
Okay.
Our customer has not paid since October of 17. Allegedly, she got in an automobile accident. Took it to this auto body shop. It's been there since maybe January or February. We've been trying to get our car back. Insurance company can't get a hold of the customer. We can't get a hold of the customer. Supposedly, he took some parts off the vehicle. The car's just been sitting there. And so we want our vehicle back. There's a $14,300 balance.
Well, you know there's a maximum recovery in small claims court anyway.
Right. That's what we're asking.
You're a corporation, so you're limited to $5,000.
Right. And we're not going to collect the balance.
You want the car back?
That's what we're trying to inspect the vehicle, so we don't know if the vehicle's worth it. We don't know if the engine is blown or mechanical problems, major mechanical problems. It's a 2017 Mitsubishi Mirage. So,
well, you know, most people don't know this, but you can have relief other than strictly for monetary amounts. You know, I could order them to return the car.
That's what we'd like.
Well, if you did that, well, I have to check the complaint to see if you requested that relief. If you didn't, I can't add it.
Okay.
If you did, then I can.
I don't think she did. So can we dismiss?
Let me take a quick look at the complaint. At the claim. Why was it continued the last time?
Because we were trying to figure out if the vehicle was worth making some sort of arrangements with the auto body shop, but he won't let us inspect it.
He's not asking for anything, so you want
the max. Yeah.
But you want money.
Well, if you can,
and then you don't get the car, you know.
That's what I'm saying. If you can order us the vehicle, if I can refile this.
Well, what I can do is issue what's called a conditional judgment.
Okay.
It's a technical thing. I can order him to return the car to you within 30 days, and if he doesn't, then you get the judgment for the full amount. That way, that's the best of both worlds for you.
I'll take that.
I would imagine so. My only concern is we're technicians, believe it or not. We follow the law to the maximum.
I went to law school.
Oh, you did?
And I had passed the bar exam. I'm working on it.
Okay, well then you understand. I can only do what the parties request, right, unless I allow an amendment. And I don't think I can allow an amendment under these circumstances because you'd be asking for potentially more than what's in the claim. So it's limited to $5,000 in any case. I've done this before, by the way.
Okay.
When we're returning a property, if they don't return the property, you get the monetary judgment. You don't care about the car. You just want judgment.
I think
I'm just concerned that from a technical standpoint, they don't own the car. They're just holding on to the car. They're really they're just a bailee. And I don't know where you get monetary damages against the bailee since you're not a party to any agreement. You really are a third party. Or what I'm going to do is I'm going to order them to return the car to you. And if they don't return the car within 30 days, they'll be obligated to pay you the amount of $5,000 because they are holding that car hostage.
Hostage, correct.
And that may be sufficient enough to give you standing to pursue an action for damages.
I personally tried to resolve it with these people.
Well, looking at it prospectively, if you got the car back and it's worth more than $5,000, you did better.
Exactly. Exactly.
And I'm not here to help you get more than you're supposed to get, but I'm limiting the recovery to $5,000 in the event of a non-return. So that probably protects you in both directions, and it gives the defendant, who's not here, at 950, an opportunity to return it without having to pay you anything.
Correct.
So you will no longer be hostage. The part of this court, for people who are still here, is to do justice, and this is called equitable relief, as opposed. You may remember that from law school.
It's been a while, but yeah.
Well, it's been a longer time for me. This way, the court is doing equity and doing the right thing. I think under these circumstances, this is a justifiable decision.
Yeah.
So you'll get your conditional judgment in the mail.
Conditional judgment. Okay.
We won't do that for, so you're gonna have to have like a hearing to come back and see if they did return the vehicle.
Yeah, I'll tell you. I'll set it for.
And their judgment and so forth.
I'm going to be here August 28th. So what I'm going to do is I'm going to give them until August the 28th to do it.
Okay.
So I'll continue the. I'll set it for an order to show cause for that date.
Okay.
To see if whether or not it's performed or not.
Same time?
Same time, yeah. Does that work for you, Murray?
15 or 36.
Yes. So I'm going to put down here conditional judgment. Defendant to return vehicle or pay $5,000 to the plaintiff. OSC recompliance August 28th. This department, same time.
And I'll send those.
Yeah, court will give notice because it's a little more complicated than usual.
Thank you.
Okay.
Okay.
The defendant has a right to appeal when he gets to judgment, so if he thinks it's the wrong thing to do, I'm sure he'll let the court know. Okay?
Thank you, Judge.
Okay. Okay, that was the original hearing. The next tape is very short. It was the August the 28th time for the parties to appear to let the court know if there's been compliance. So what you're going to hear now is that nobody showed up, and I had to make a decision as to what to do about it.
You want to do it after the break? Or you want to do it now?
And I'll tell you what. Let's do it. Let's do the actual tape right now, and then we'll take the break, and then we'll talk about it.
Okay, here we go.
Corporation versus I&A Auto Body, and then I&A Auto Body versus M&N Financing Corporation. Anybody here for either of these cases? Is the defendant present or cross defendant? Nobody's here? No one is here. We worked working this up. Okay. Well, this is a case I decided months ago. Are those other people there? I don't remember seeing the kid here before. Okay, they're not coming in, so I guess it doesn't much matter. Okay, with regard to these two matters, cases ending in number 1054 and 5001, there's no appearance by either party. It is now 11:36. The matter is dismissed without prejudice. Yeah. Let me see what decision I made. I think this was a compliance situation. Okay. I had ordered the plaintiffs to return the vehicle. Sounds like a familiarity. Or the $5,000 fee would be imposed. That was the decision that I think I made. I'm the fourth judge that's on this file. There are orders from 3 other judges. I heard this case on July the 10th. Defendants were ordered to return the vehicle to the plaintiff, or a judgment in the amount of $5,000 would be entered forthwith. Order to show cause scheduled for today. Compliance of conditional judgment is scheduled for today. Nobody here. So, I don't know whether they returned the vehicle or not. So judgment will be entered for $5,000. Pursuant to the minute order of July that I made that decision. There were several appearances afterwards. Are there multiple defendants? Yes, there are. Yeah, I guess defendants jointly and severally. And that leaves us with number... Okay, so that's what happened. Nobody showed up. Now, I had several choices, which we're going to talk about right after the break.
Okay, this is for the people, Judge Herb Dodell. If you want to ask the judge a question, askjudgeherb@gmail.com. We'll be back with the judge's decision right after this.
AM KCAA. Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, we start off with the fact that I basically agreed to enter a judgment for the plaintiff for $5,000, but if he got the car back, he wouldn't get the money, he would get the car, which presented a very interesting point. There are limits in small claims court for corporations, which this was, limited to $5,000. Individuals are entitled to go up to $10,000. But if you think about the possibilities here, let's say that's a 2017 Mitsubishi. Let's say the car was worth $12,000. And the conditional judgment says if you give him back the car, then you don't have to pay him any money. So if they gave him back the car and the lender sold it for $12,000, they really would be exceeding the jurisdictional amount of the court. But we don't have to go that far. Returning the car is an act of equitable relief that we can do without regard to the amount of money that's involved.
Well, how about if the owner of the car paid the guy $5,000 and then sold the car for $12,000? He makes $7,000 on it.
Well, the owner of the car, the one who was in the automobile accident, was nowhere to be found. So it was a question of whether or not the lender could for all practical purposes, it was a repossession.
Yeah, but I mean, they were suing the repair,
the people that was storing it.
Right.
And probably did some body work on it. Yeah. Maybe not. If they didn't get an authorization from somebody, they probably just store it, and they charge. I've had a lot of storage cases, many. And so I granted what's called a conditional judgment. And I set it over for another date to allow for compliance. And when the date came and nobody showed up, I was left with really two options. Number one, I could dismiss the case because if I believed that there had been compliance, there's no reason to have a monetary judgment because the guy got the car back or the company got the car back. But I didn't know that. There were no facts before me. I know there was a cross complaint that was filed against the plaintiff, but they didn't pursue that either.
It's weird that they never contacted the court.
A lot of times they don't, because generally we tell people is if you've complied with a condition when we have a conditional judgment, nobody needs to show up, and I just dismiss the case as though everybody has gone forward with whatever the agreement was.
But you didn't dismiss it.
I granted the judgment.
Exactly.
I could do that because if he had really complied, if the defendant had really complied, even though they didn't show up, they could have made a motion to set aside the judgment on the grounds that they had complied and provided evidence that they had done so.
But they still have to go to court to do that.
They would have to go to court in both cases, because if I dismissed it and there hadn't been a compliance, the plaintiff would have refiled it. And they would have reserved it, and we would have been stuck for another case on the calendar. I've told this so many times, I don't want to repeat myself. I've had days where I've had as much as 86 cases in one day. We don't have a lot of time. We don't want to waste any time with unnecessary things. So I figured, well, we'll give them the judgment, and if they had complied, they'll be back here to show that they had. And if they hadn't complied, the lender didn't have to do anything. He got the judgment. The conditional judgment ripened into a real judgment. So what I'm saying here is these are all discretionary calls. I could have done several different things, but I didn't.
What the weird thing hearing this was this went before 4 different judges. And then at the end of it, at the end of the whole mess, they didn't even end up showing up to resolve it.
Yeah, but I gathered from looking at the file, because I didn't know the first time that I heard the case that there had been a cross complaint, that the storage company was looking to get money back from somebody.
They had made it after you'd heard it?
I guess so. And when I picked up the file on the second appearance and I saw there was a cross complaint, I knew it was more complicated than I wanted it to be. And I figured, well, the conditional judgment is what it is, and that's all there is. There's no action at all on the cross complaint because they never pursued it. So technically, I could have just dismissed the cross complaint for non-appearance, or what they call take it off calendar.
So is this $5,000 still could possibly be on the books?
Well, the lender's got a $5,000 judgment.
That's what I'm saying.
Yeah,
so
they're going to collect it.
I mean, there's a collection for $5,000 on
this.
Yeah,
the lender's going to get the $5,000 if he can collect it from the storage place.
Strange. It's just the whole thing is weird.
But this is not an unusual type case.
Oh, I know.
I wanted to play it because the only reason there's a recording of it, we record every case. But what happened was I had taken it under submission because I didn't really know what I was going to do after I heard the non-appearances and I'd been in court on it. And they called me from the clerk, but the clerk called me and said, you didn't give us a ruling on that case vis-a-vis the non-appearances. I said, you know what? I probably had 30 cases that day. I don't remember all the facts. I can't remember all the details. I take notes and things, but I didn't remember all the details. So I said, send me the tape.
Is the court system still like that, where there's 50, 60, 70 cases being heard?
Go to Inglewood. Go to Inglewood
sometime.
No,
I don't want to. Thank you.
No, Inglewood was the heaviest counted, followed by downtown. When I was sitting downtown, which I did for a long time, in small claims court downtown, we would average probably 30 cases a session, 2 sessions a day. Probably got up to 50, 60 cases a day.
That sounds like a lot.
It's a lot everywhere. When I was doing restraining orders, all those years that I was doing restraining orders, we averaged between probably 25 to 35 cases a day, I would guess. Not all of them go to trial, of course.
Yeah.
You have non-appearances. Those cases go away.
Yeah, mine took 15 minutes.
That's generally all you're going to get, actually. So the second case is kind of an interesting case. I like this case.
You do?
I did.
Okay.
I listened to the tape. I said, no, that was not a bad deal. Here we get into a different concept. It's an equitable concept called rescission. And when you hear the actual trial, after the trial is over, I'll tell you what I did. Well, you'll know what I did because you'll hear it on the.
Well, what's the case about? What's the case about?
It's a timeshare.
Oh, the timeshare case. Okay, this is the timeshare case.
Yeah. So.
You ever own a timeshare?
I hate to tell you.
You have.
My wife wanted to get a timeshare. I opposed it, mind you, but she convinced me that it was a great deal. And so I just rolled over, I said, okay, you want a timeshare?
Gotcha.
We got a timeshare. Now I'm going to figure out a way to get out of it.
Yeah. My mom used to sell timeshares. That's why I'm in Lake Tahoe, South Lake Tahoe. So that was actually nice. Okay, here we go.
Play the tape. Number 5, Lawson versus Trading Places International. Case ending in number 2952. I read this file as well. Are you Ms. Lawson?
Yes, I am.
Any appearance by the defendant, Trading Places International, LLC, or there appears to be a second defendant, Premier Property Management? Any appearance by them?
No.
Vacation Resorts International? Any appearance by them?
No.
Global Travel Service, LLC? Any appearance by them? It is now 10 minutes. It's now 7 minutes past 10. Were these defendants all served?
2 of them were. The other 2 are out of business. The first time around they were served, but then I didn't make the court case because I didn't know about it. So the second time around, 2 of them were served. So Trading Places and Premier Property Management.
They were both served?
Yes.
And the other 2 were not?
One's out of business and the other one they couldn't get hold of.
Okay. All right, this is what we call a prove-up. You need to tell the court, and I read your file, it's a $10,000 claim. You're an individual, so that limit of $10,000 limit applies. All right, tell me what happened. You bought a timeshare.
Yeah, another one. It was in 2014 that we were approached, my husband and I, to do a timeshare presentation at a golf resort in Cabo San Lucas. At that
What
time,
place was that?
what was it called?
Yeah.
Golf Villas.
Okay.
Um,
When you say you did a
Approach.
presentation,
yeah,
were you
So-
the buyer or seller or salesperson?
they
Or
were trying to sell to us.
they were trying to sell to you?
Yes.
Okay, so you were the customer, the potential
Correct.
customer. And did you go down to Cabo San Lucas for the presentation?
Well, yes, we
And
go
they
down.
walked through the property for an hour or so, and they gave you a drink and
Something
sold
like
you
that.
a timeshare.
Something like that.
God, it sounds like a familiar story. Okay, so you bought this timeshare, and what happened?
Well, the thing is, my recollection, as far as I understood the whole conversation, I did not buy it. I already have 2 timeshares in Cabo San Lucas. And when I was approached to talk about this, I was promised that I could trade one in to receive this one, which was paid for and valued at $23,000. So based on the conversation, that's what I did. I offered to trade in my Cabo Villas timeshare to purchase their Golf Villas timeshare. It was a trade. It was not in addition to my 2 timeshares, which I told him straight in the eye. Why do I want 3 timeshares?
Why do you want 2?
Well, you really want to know?
Yeah.
Well, the one is on the ocean, which my husband and I got married there, and it's very private. And then I bought Cabo Villas for my children because that's kind of the party side at Medano Bay. So, it's true. That's what I
It's
had.
always nice to get a little background data on these things.
That was actually a very
Because
big...
people buy timeshares you don't know how many times I've heard people unhappy with buying a timeshare, and they want their money back. But they have to look at the contracts,
Absolutely.
and then the contract tells us what the terms are between the parties.
Correct.
And many times, people tell us, but we agreed to this and that, but it's not in the contract. If it's not in the contract, it doesn't exist, generally. Okay, so what happened?
So I guess my case in point is it's not my first rodeo. I have 2 timeshares. I know how it goes. But in this particular case, they had promised to take my Cabo Villas, buy it from me, rent it out so they could get monies that way. If I agreed to buy their Golf Villas resort and give up the first 5 years of my ability to use the resort, and they would pay me $1,000 each year thereafter.
Is any of this in writing?
Yes.
Okay, let me see what you have.
When I first started doing this, Premier Property Management was asking for monies, which I did give up front, $1,000, and then another $8,115. But as soon as I found out that the case was they weren't going to buy the property, they were going to try to sell the one I'm trading in, I asked to speak to a supervisor. And I got no response.
Hold on a minute, ma'am. Let me
Sure.
just take a look at this document. Mr. Espinoza, when are you going to write this withdrawal?
I'm gonna call in today and I'll write it. It'll be this weekend because I gotta get home.
Okay, no, that's okay. It's just that there's no date by which you have to do this. But that's okay. You're telling me you're going to do it this weekend.
Well.
You'll write a letter this
Monday or
weekend, right?
Tuesday at the very latest. I will
Okay,
have
I'll tell
my
you what.
Certified letter.
And make sure you send a copy to the other side, right?
Oh, Your Honor.
And if he doesn't get a copy of a letter from you in, say, 10 days of the letter that you supposedly send, he's coming back.
I understand,
Okay?
Your Honor.
So you need to do it, like, right away.
I understand, Your Honor.
And you understand that, Representative from Acme?
Yes, Your Honor.
You'll get a letter, a copy of the letter he's gonna write withdrawing it.
Yes.
Okay, the money part is taken care of here. All right, the court finds you can stay where you are, you don't have to come out.
The court finds that the settlement is knowingly and intelligently made. Both parties understood the nature and terms and conditions, especially the fact that there's going to be a letter withdrawing any complaint against Acme bail bonds. Case is dismissed without prejudice. Court retaining jurisdiction pursuant to Section 664.6 California Code of Civil Procedure. All parties are mutually released. All right, thank you very much.
Thank you, Your Honor. Thanks.
All right. Go ahead, ma'am. Sorry to interrupt you.
That's okay.
Good fight. Amen. Yeah.
Okay, go ahead.
So-
Don't be intimidated by the fact
I'm
that we're all
not.
sitting over there.
It's okay. I just appreciate you listening. So in any case, there was no response. I'm talking to a supervisor. So over the next 2 years, from 2014 to 2016, again, we go down every year. We have a fixed timeshare in Playa Grande. We actually approached the golf villas to try to solve this matter, and actually found the gentleman that sold me the timeshare, and he said he was going to make it right, but it didn't work. So long story short, I then sent a certified letter to the gentleman that represented Los Cabos Golf Resort. I have certification that it was received. Basically gave him more time to respond to me in a manner that we can discuss this, and no response. Out of the contract, you'll notice the only one that I've signed is the agreement that they would market or they would take on Cabo Villa's resort.
So you're Wendy Lawson?
Yes, I am.
Okay, I was looking at the marketing agreement dated April 1st, 2014.
Again, the impression I had was they were going to take in my Cabo Villas, hence this is the only one that's signed out of all the contract.
Okay, a quick question.
Yes,
What about title? Whose the title holder?
of the golf resort.
The one that you bought or what you were trading?
I
for?
am. And my compromise was just give me my money back, you take your timeshare back. That's all I wanted.
So everything is still, you still have the 2 timeshares in your name?
I still
You
have, I
and your
now have
husband.
3 timeshares.
Now you have 3 in your name.
Yes,
So you've got an asset, whatever that asset's worth. That third, let's call it the third condo. That's yours. You're the current owner.
in theory, I have nothing to prove
Not in
that.
theory.
Well, I have no contracts to prove that.
Well, you have title, don't you?
We don't get a title.
You don't get a title in a timeshare?
No,
What do you get to show your ownership interest?
what I gave you.
A marketing agreement?
Marketing agreement and the contract that only they signed, not me.
Well, I'm only interested in contracts that are signed by both parties. There's a document called sales contract. It says payment, $8,112. Did you make that payment?
Yes, I did.
And you're asking for $10,000. What is the basis for the amount of your claim? You don't want it, right?
What's
You
that?
don't want this timeshare.
No.
So basically what you want is to give it back to them, and they give you back $10,000.
The money that I gave them.
Well, you're saying it's $10,000. You gave them $8,100, right?
1,000 in one transaction and 81.10 on the second transaction.
So it looks like $91.12.
Correct.
Okay, that's what you want back, $91.12.
Correct.
And you're willing to give them back the ownership interest or whatever they call it
Yes.
in this timeshare.
Yes.
So you basically want us to order the equivalent of what's called specific performance. Okay. And you say you were misled or misrepresentations were made to you about this transaction?
Correct.
And let's assume for the moment that they said, okay, we'll take back the second condo and trade it on the terms and conditions you discussed. Would that be something that would be appealing to you?
Not any longer because it's been over 3 years. This is no longer the same transaction 3 years ago that it was offered to me.
I'm wondering whether or not there's a document that when there's a reconveyance or if somebody sells a timeshare, they must get some kind of document giving up their interest in exchange for something. What would you get other than the money that you'd have to sign to reconvey whatever it is back to the timeshare company?
I do not know. I've been in the mortgage business 27 years. I'm very familiar with the reconveyance. I have never given
Well, if there's
back.
no conveyance, then there's no reconveyance. That's why I asked you the
Right.
question about title.
I have reconveyed deeds of trust on a regular basis, but I've never reconveyed a timeshare.
Yeah, well, I haven't either. We learn new things every day. There's got to be some document that allows for the equivalent of a reconveyance. If they're ordered to give you money, you have an obligation to give them back whatever it is that you claim you didn't really want, or whatever the terms were.
Right.
I don't know the answer to that question. Is there some document that these timeshare companies expect from somebody when they buy it back?
I do not know.
Hmm.
But everything I've given you is what I would receive.
No, I understand the issues, and I looked at the documents. I'm inclined to give you the money back because there's no defense, and I find your testimony is credible,
Thank you.
and that you met your burden of proof by preponderance of the evidence. I'm satisfied that you've done that. I'm just wondering about the mechanics of this.
Sure.
When we had, to make it even more complicated, is this a Mexican company or is this an American company?
The companies that were served here are American.
Okay, so we have jurisdiction over them.
Yes.
Uh,
The only thing I can offer is I have a friend in Mexico, actually has sold me my first timeshare, and she would know the legalities, but she's not an attorney. I could ask her.
Well, what I'm thinking about doing, because we're mechanics, this job, believe it or not, we're mechanics. We don't fix cars or anything, but we're mechanics. And I need to frame an order or judgment that, one, is enforceable, number two, is legal. I have the ability to order them to return the money to you. That's easy. That's a money judgment. That's not very complicated. The real question is, what do you do in exchange? If you get the money, I can suppose I can order you to provide whatever documents they may need as a condition to their paying you.
Correct. And
That would
whatever-
probably satisfy it.
Or whatever it is I need to sign for them to take it back and put it in
Yeah,
their
well,
name.
whatever the document is that will
It's a
satisfy
quitclaim
them.
deed and a deed of trust, but I don't know
I'm not
that.
so sure it's a quitclaim deed because you don't have property, you don't have ownership of it. You have ownership of a time, a couple of week period or whatever it is that it's in your timeshare. I'll tell you what I'm going to do. I'm going to fine for the plaintiff for $9,112.
Okay.
Conditioned on your providing them with whatever documentation they need to, for want of a better word, reconvey
Okay.
whatever it is that you had. It's not title.
Okay.
You'll have to reconvey it. But you'll have to communicate with them. Because
Absolutely.
they're going to get a judgment in the mail against them for that amount, this amount of money. The judgment will be against the two parties that were served jointly and severally, and against either or both.
Okay.
I'm going to have to craft an order that will say this. I'll do that.
I greatly appreciate it.
Okay. Here, Mr. Bailiff. Thanks. All right, I have to write something up for this one.
Are you going to get back to her, sir? Or?
What do I do now?
You'll get the judgment in the mail
Okay.
after I write it up.
Craft it up.
That's probably going to be this, I'll probably do it this weekend.
Okay. Thank you.
All right, it's not taken under submission. Judgment for the plaintiff in the amount of $91.12, subject to the condition that you respond to any need by them. If they don't tell you they want anything, you're excused from that condition.
Okay.
It's up to them if they want some document to show that they have title back or ownership back, whatever they call it. That's up to them.
Absolutely.
If you don't hear from them, you just got a money judgment. That's the end of that.
Fair enough.
I'm not going to make it conditioned on them doing something and them deciding not to do anything to avoid paying the judgment. The judgment is the judgment. The monetary judgment is the monetary judgment. Okay? Understand it all?
I do.
Okay. All right. Good luck to you.
Thank you.
And Cabo was a wonderful place.
It is.
I was
I've
just
got
telling
many
some.
timeshares if you want to use one.
No. I was just telling somebody in the elevator this morning about Cabo San Lucas.
Yeah.
It's an hour and a half away. It's beautiful. We were just there a couple of months ago, and we stayed at one of these resorts. It was wonderful.
Where'd you stay?
What's the name of it? It was very, very nice. My wife did it all. I just showed up.
That's right.
Okay. But it was very nice.
Well, great.
A resort, all-inclusive, one of those all-inclusives.
My husband and I actually got married on the beach at the one first one I bought, so it's pretty special to us. We go every year.
Yeah, it's very nice.
Love it.
Very
Thank
nice.
you so much. I
Okay.
truly appreciate
Well,
it.
hold on a second.
Oh.
The two parties that
Dismissed.
we're dismissing them.
Yeah.
Thank you.
Dismiss the other two parties.
One of the other parties got served. I just got the letter in the mail, but it's too late, so I didn't send it to the court.
Well, you got to get judgment against these two jointly and severally only.
Okay.
Okay?
Okay.
All right, Allstate Maintenance versus...
Okay, that was a real case, ladies and gentlemen. You heard it just as it unfolded. She was an impressive person. I liked her. Not that personal feelings make any difference at the end of the day, but she got convinced to make this deal with them, and they were sounded like misrepresentations. But the legal concept is called rescission. Rescission means that you take the agreement and you declare it to be null and void. It doesn't exist anymore.
If she's in the mortgage business for 27 years, she knows better than buy another timeshare and all. I don't know. I feel differently about it, tell you the truth.
Well, the reality.
I think she's stupid.
I'm kind of embarrassed. I'm really embarrassed. The timeshare that my wife talked me into is in Cabo San Lucas.
Yeah, I mean, they're beautiful. I mean,
And
love
it was
Cabo
very
San
nice.
Lucas.
And
Yeah.
we had a great week, and they took us around.
Of course.
Get the morning drink and
Yeah.
fruit, and
They kiss your
so-
butt.
Oh, they were unrelenting.
Yeah.
But the bottom line, rescission means that you get to start over again. But a condition of rescission is that you have to return whatever it is that you got. And that's the reason why I was saying to her that if they wanted some document to show that the property was going back to them, even though it wouldn't be a classic reconfirmation, the fact of the matter is that they had a right to get back whatever it is that they needed to make themselves whole.
I'm surprised they didn't show
by the
up.
way.
Yeah, go ahead. I'm sorry.
They never did. They never did show up.
Yeah, that's why I
The
don't
judgment
understand.
stuck, as far as I know.
That's weird.
And by the way, only defendants have rights to appeal, except if a defendant does not show up, they do not have a right to appeal from the judgment. They have a right to make a motion to set aside the judgment on the grounds they weren't served or it wasn't timely or those other things, and that they can appeal from. The denial of that motion is appealable. But I didn't make it really clear in this last case about appellate rights. When a defendant doesn't show up, the testimony of the plaintiff is to be considered without dispute. And that's why I agreed. If they had been there and they said there was this dialogue and whatever, the ruling may have been different.
Well, the crazy thing is that the company was here in the United States. You said San Diego.
Yeah, San Diego.
And said if they were in Mexico, I could see not appearing. But I mean, it's a 2-hour drive. Why wouldn't you show up for And now they got a judgment, and now it's sticking. So
no, the judgment is assuming the company's still around. And joint and severally, by the way, if you heard me mention that term, when there are multiple parties and the judgment applies to either of them individually or collectively. In other words, you could collect from either one of them or from the entity itself if there's an entity. But rescission is equitable relief, basically just setting the parties back where they were before. I'll make you another good story. Same court, as a matter of fact, relatively close time, same thing. Lady came in, and there were both parties present at that time. came in and said that she had bought a 6-year warranty on repairs on her car. It was a pre-owned car. And the first year and a half, everything was fine. And then when she went back in towards the end of the second year, they said, oh, warranty's expired. She said, what do you mean it's expired? It's a 6-year warranty. He said, well, look at the fine print in the contract. It says 6 years from the time the car was first offered for sale, when it was new. So in other words, I said to the defendant, who was there from the car company, I said to him, what if she had bought this car and this warranty and 5.5 years it expired? Would she have only gotten 6 months? He said, that's right. She would have gotten 6 months. It's in the contract. I said, well, you know what? I'm rescinding this contract because I think there was fraud. One of the bases for rescission, by the way, I should tell you what the bases are, is either a misunderstanding, a failure to perform, or a fraud. Misrepresentation is called fraud. The term we hear, fraud, all the time, generally means that somebody either said something that wasn't true or withheld or concealed information which was true, which would have been relied upon by the other side, and in reliance thereon, they suffered damages. And so what I did is I rescinded the contract. She owed no more money on the payments, and they had to give her back the difference between what remained on the period of time, because obviously she was not going to get her car fixed there anymore. And I think she had about another 1.5, 2 years. I ordered a monetary judgment against the car company. And that's basically rescission. It's the same kind of thing. Lemon law, that's basically the same thing. That's a rescission too. You want to take a break?
Yeah, let's take a quick break because the show's almost over anyways. But we should take a break because we want to sell your book, From the Trench to the Bench, and all that.
The revision is being done tomorrow.
Oh, cool. And it's available on Amazon.
Amazon, yes, From the Trench to the Bench.
Everything you want to know about the legal system.
It is. It's for people who don't know. See, today's exercise really was an effort to provide practicality. If you're going to be in a situation that even closely resembles what you just heard, you have some idea of what you can expect.
Go to small claims court.
I think small claims court is the best of all the courts. Personal opinion.
We'll be back after this.
Did you ever meet a lawyer that was for the people? Someone who had the best interests of the people at heart? Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
And by the way, the subject matters that I'm talking about, equitable remedies, which is a fancy word for what kind of damages that you can recover, is covered in the book in Chapter 1, dealing small claims court, and in Chapter 7, which is breach of contract. Breach of contract means one party does not perform or does something that is violative of the terms of the agreement that the parties have. And so I want to cover the last few topics very briefly. I go into it in much greater detail in the book, obviously. Next concept is called reformation. Reformation means that the parties come in and they want to reform or change the language in a written agreement. And to do that, they have to show that the parties intended something else. In other words, they had an oral agreement that didn't get memorialized properly. The terms were incorrect. And that happens every now and again, not too often. Third is called restitution, and that applies both civilly and criminally. In a criminal case, for example, if you are the victim of a crime, somebody beat you up or burglarized your house or whatever it may be, when the defendant is found guilty or enters into a plea agreement, either one, you as the victim are entitled to what's called a restitution hearing, meaning that you present to the court, to the judge only, what your damages are. And that could go as far as including attorney's fees. And as a condition of probation is the way it usually appears, The defendant has got to make what's right. If they don't, they may be in violation of their probation. It kind of cuts pretty close to imprisonment for not paying debt, but it's basically a condition of probation because probation is a privilege, not an absolute right. So that's another concept. The next and last one for today is called specific performance. In the case that you heard a few minutes ago, I had mentioned specific performance, but the terms and conditions, once I heard all the facts, did not lend itself to that. Specific performance is generally you want the party with whom you made an agreement to specifically perform the terms of that agreement. For example, you bought a piece of jewelry which was very close to your mother's jewelry before she passed, and it's kind of unique. Generally, specific performance deals with some things that are unique. You can force that seller, if they refuse to give it to you, you can force that seller to sell it to you because that was the terms of the agreement, and there is no other adequate remedy at law in terms of damages because it's a unique piece of jewelry. Same thing applies to property and the rest. I should also mention why I like small claims court so much is the rules of evidence are really relaxed. In many of these cases, people want to talk about things that are not in the document. Normally, there's something called the parole evidence rule, meaning you cannot vary the terms of an agreement by saying something else happened, but you can use parole evidence to explain things. So if something is ambiguous, you can, especially in small claims court, you can use whatever the dialogue is between the parties to explain the terms and conditions of whatever it is that you're claiming. This is called equitable relief. I mentioned punitive damages. That's called punishment damages. Generally does not apply to contract cases. They generally apply to what's called torts, civil wrongs, things of that nature. And it's based on an effort to punish the party that did something willfully and in conscious disregard of any of your rights. It's limited. There's a Supreme Court case called
KCAA Loma Linda, 1050 AM.